This is cause number 25 CCCR 2116, case of style of state of Texas versus Travis S. Hingston. Mr. Hingston, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Hingston, you may put your hand down. How are you doing, Mr. Hingston? I'm doing fine, thanks for asking. Now, Mr. Hingston, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature? Mr. Hingston, before you sign and initial these documents, did you read the documents? And did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Hingston, I read your answers. Based on the answers, you meet the eligibility requirement for the court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Christy Cawthon. Attorney Cawthon will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, Mr. Hingston, you'll be free to go. Now, he has a felony case that's already set. And this is his court date, July 6th. That's when his felony court date is set. Mr. Hingston, your case is going to be reset to July 6th, 2026 by our court coordinator. You'll get your reset from the court coordinator. Once you get your reset, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall.
So,
Mr. Crowder.
Yes,
Jeff
sir.
Crowder.
Yes, sir.
Okay, now, Mr. Crowder, you're supposed to be here and you need to, your court date is gonna be reset. We have another case that's going to trial. You need to be here in person every time that you come to court, okay?
Okay.
All right. Just a standard. What? This case is gonna be reset to June 29th, 2026 at 9 a.m. You need to be here in person.
Okay.
All right? You're free
All
to
right.
go. You have a blessed day.
You too. Thank you.
Stay in contact with your attorney and Mr. your bondsman, Mr. Burbank. Your attorney is currently present in court, getting ready to go to trial on another case.
All right. All right.
All right. You're welcome. All right. You have a blessed day. As Mr. Living, you'll sit next to Mr. Turpin. Is that Bahat? Bahat?
Yes, sir.
Okay, you'll sit next to Ms. Living. Dan Zeisen. Okay, you'll sit next to Ms. Bahat.
Here, number 7, Jacob.
Mr. Thomas,
Yes.
you'll sit next to Ms. Dan Zeisen.
You got it.
Okay.
Ms. Jacobs,
Yes.
you're gonna sit in this first chair, in this, yeah, right up here.
Here?
Yeah, right there. And Vega,
Yes.
you're gonna sit next to Ms. Jacobs. Ms. Lyle Beenan,
Yes.
you'll sit next to Ms. Vega. Ms. McBride, you'll sit next to Ms. Lyle Beenan, right there. Is that Mr. Lormier or Lormier?
Lord.
Farmer? Oh, sir, ma'am, you have to sit next to her? Yes. And you're gonna sit in the chair that she was sitting in, next to her. Mr. Hewitt, you'll sit next to Mr. Longmire. Arante, you'll sit next to Mr. Hewitt. Yes, right there. Mr. Blaze,
Yes, sir.
you're gonna come to that second row of seats, look all the way down to the end. In the second group of chairs, sit in that first chair. Oh, keep going, all the way over there. And Miss Conley, just follow him and you'll sit next to him. Miss Kreshner,
Yes.
you'll sit next to Miss Conley. Miss Wright, you'll sit next to Miss Kreshner. Mr. Kokonos, you'll sit next to Miss Wright. Yeah, you're gonna sit next to her.
Oh.
Yes.
Yeah.
And yeah, and Trahan, you'll sit next to Mr. Coconuts. They just have tapes on the seat. There's nothing wrong with the seats. They're not broke or anything. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your most serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive. Now, this case that we have today is the state of Texas versus Trevani Slaughter. This case will be tried expeditiously, consistent, which will require a careful and impartial trial. Now, unless otherwise instructed, you'll be permitted to separate yourselves for breaks, for recess, for meals, and at night. Whether you are selected to serve as a juror today in this trial, you should bear in mind that you are performing a significant service which only 3 people can perform. If you're selected, as I mentioned to you earlier, our case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected, unless otherwise permitted, as I mentioned to you earlier, you will be permitted to separate yourself for recess, for meals, and at night. Now, our courtroom hours are normally from 9 to 5. In this court, we have more than one docket. A docket is just a list of cases. The cases are going to be put in one of several categories. One category could be for jury trial. Another category can be for an announcement where the attorney will come to make an announcement as to whether or not they want to, if they need more time to prepare for trial, or whether or not they wanted their case to be put on the trial docket. And we also we have what is called a pretrial conference docket. That's a lot of times we may have what is called pretrial motions. There are motions and hearings that we have before the trial actually starts. Okay, now our courtroom hours, as I mentioned to you, vary from 9 to 5. However, at 9 a.m. in the morning, up until 12, and sometimes a lot of times after 12, sometimes even to 1:30, 2 o'clock. Our dockets sometimes are so large that we are still in court. And so we start our jury trials at 1:30 in the afternoon. Now, you should bear in mind that we have district courts and we have county court at law courts. This is a county court at law court. The district courts, if an attorney is scheduled to be in district court and county court at law at the same time, the law requires them to go to district court first. And so we have to wait until they finish in district court to come to county court. Now, or even if they have to go to another court in a smaller county, the smaller county has priority over a larger county. And so a lot of times, because of the fact that we are the county court at law, we have to sometimes wait on attorneys to finish either in district court or in the smaller counties before we can move forward. Okay, so I've just said that to inform you that we had a situation like that today, so we apologize for any inconvenience that you may have experienced. Now, I have an administrative matter that I must tend to. That is, I must administer to you 2 oaths. Okay, I will first administer to you the first of the 2 oaths. So I need each and every one of you to raise your right hand, and I will swear you in. And once I finish swearing you in, please say, I do. Do you and each of you swear affirm that you will answer truthfully to such questions as may be propounded to you by the court or under its directions touching your service, qualifications as jurors, so help you God? Please say, I do.
I
do.
Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I determine or discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and be given a fine up to $500. Now, the first thing I'm going to do, I'm going to ask you a series of questions. I do not want you to answer those questions out loud. Just please answer the question to yourself. And once I finish asking the last question, I will then ask, is anyone disqualified under the law? And if you think that you may be disqualified under the law, I'll ask that you just raise your right hand, and then we'll bring you up before the bench to discuss the matter more privately. Now, when I use the term more privately, when I'm talking about, currently we are airing on YouTube. We'll turn the YouTube off. We'll turn off the microphone, will be turned off. And I have a noise sound device that sounds like this. That will be turned on. That will be turned on as well, so that we can discuss the matter more privately. So again, before we get started, I will ask a series of questions. I do not want you to answer those questions out loud. Just answer it to yourself. And if you think that you may be disqualified under the law, when I ask the question, is there anyone disqualified under the law? You raise your hand and we'll bring you up before the bench and discuss the matter more privately. Okay, first question. Except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the laws and constitution of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, before I ask the next question, I need to tell you that I am required to ask this question by law. I'm not trying to pry into your personal affairs. I'm only doing what I'm required to do by law. And the next question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a pettit juror for 6 days preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? Now, that was the last question. Is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Let the record reflect that no one raised their hand. Now I will move to exemptions. And I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. Now, I will ask these questions in the same manner that I asked the previous set of questions. That is, I will ask a series of questions. I want you to answer those questions to yourself. Do not answer those questions out loud. And then once I finish asking the final question, I will then ask, is there anyone who would like to claim an exemption? The first question, are you over 75 years of age? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a pettit juror in Jefferson County during the past 3 years preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of your county of residence? Okay. Is there anyone who would like to claim an exemption? Okay, we have one person. Is that Miss Kreshner? Okay, Miss Kreshner, you can come forward. Is there anyone else on the panel who's claiming an exemption? Let the record reflect that no one else on the panel is claiming an exemption. Now I'll move to excuses. With the excuses, I'm not going to ask you a series of questions. I'll make 3 statements. Now, if any one of you feel there's a reason you cannot serve based on the statements that I make, then we'll ask that you'll come forward and we can discuss the matter more privately. First statement, a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and without the consent of the state. And this is the last statement. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to exercise an excuse? Let the record reflect that no one on the panel is exercising an excuse. The rest of the members of the jury, they are not exercising an exemption. And at this time, all the remaining members of the jury are qualified to serve as jurors in this case. Let the record reflect that the court is convened for trial in cause number 23 CCCR 0951. The case is styled the state of Texas versus Travani Slaughter. The defendant, counsel for the defendant, counsel for the state, and all members of the jury panel are present. Again, members of the jury panel, you have been summoned to this court as a prospective juror in a criminal case. The defendant, Travani Slaughter, is sitting next to his attorney, Thomas Burbank. The state is represented in this case by Assistant Criminal District Attorneys, Attorney Farrah Nixon, and Attorney Samuel Masradian. The court reporter is Mr. Sebastian Aguilar. He will be taking down everything being said, so speak up when you're answering or asking questions. Our bailiff, you met our bailiff earlier, Ms. Brenda Mosby. In this case, the defendant stands charged by information with the Class A misdemeanor offense of resisting arrest, search, or transportation. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss it more privately. Is the state ready to proceed?
Yes, Your Honor.
Okay, is the defense ready to proceed? And Mr. Burbank and Ms. Nixon, is 30 minutes enough for each side?
Yes,
Okay, at this time, Ms. Nixon. Is it gonna be Mr. Maseratian? Okay, Mr. Maseratian, the panel is yours, and I'll be taking time.
make that work. Howdy, everybody. So first question I always like to ask, who's excited to be here today? All right, bunch of cheery folks happy to be here. Well, don't I have some news for you? If you don't want to be on this jury, here's a little tip. I need y'all to talk for me, all right? Be very vocal, answer questions, volunteer. Because the more you talk, the more you might say something that makes either me or my trial partner or the defense think that person might not be the right fit for this jury. And why might that be? Certain people have, I guess the best use of the word is prejudice, but that's kind of a vile word. But let's just say, for sake of example, when you were a child, somebody broke into your house and they stole your favorite stuffed animal. And now for the rest of your life, you hear about somebody breaking into somebody's house and you just can't look at it the wrong way. You just look at it the wrong way. Just that person's probably guilty. You kind of have that within you that you might not be a good juror for a type of burglary of a habitation case. But that might not mean you couldn't sit in on a regular resisting case like we have here, or a DWI case, what have you, because none of those things have affected you personally. So what I like to say, just be very vocal. So we're here on a resisting arrest or search for transportation case as the law defines it. Now, juror number one, Mr. Bergman.
Yes.
What does resisting mean to you?
Is being, somebody asks you to do something or try to direct you to do something. And go the opposite direction, or you amplified about it.
Okay. Mr. Underhill, do you agree with that, or do you have anything else to add?
I like the way he said, I do agree, and also, if you just follow directions, follow directions. In the end,
And what about you, Mr. Turpin? Do you have anything to add, or you kind of agree with what they've been saying?
Resisting can be, and it's a couple different things. It has to do with the law, then you're putting up a fight against the officer.
Gotcha. And yeah, let's take a little quick peek at the legal definition of resisting. So a person intentionally prevents or obstructs an individual they know to be a peace officer from effecting an arrest, search, or transportation by using force against the peace officer. Now, Mr. Vega,
Business.
I'm so terrible.
Okay.
No, I gotta correct that. Mrs. Vega. What does it mean to use force against a peace officer?
Basically just doing everything that they can to stop what's going on. So maybe the officer may be trying to arrest them and they're doing everything against their willpower to not be arrested.
Okay. So you say everything against their willpower. Would an officer tries to grab your hand, and let's say you just simply pull your hand away? You're not really doing everything, but would that still count as resistance?
Yes.
Yes, ma'am. Ms. Lyle Bina?
Yeah.
What about you? What does using force against a peace officer mean to you?
Be physically in contact with them in some form of resistance.
Okay. I want to paint a picture, because sometimes when people hear the word against, not that you said anything that would make me say this, but in general, I've seen this before. When somebody hears the word against, they think the force needs to go towards the peace officer. basically almost an attack, like you're going at the police officers being used against them. But I want to make sure everything's clear. If I'm pulling you this way, you're going this way, and you pull against that this way, even though the force isn't being directed towards the initial force, the pulling force, are you still going against that pulling force by going this way? Does everybody see that? I see some nodding heads. Anybody unclear about what I'm trying to demonstrate? Mr. Arante? Kind of give me a little squint. I want to make sure we're on the same page. You follow me? Yeah. All right. Now, something very important about resisting cases is that it's not a defense to resist the arrest, search, or transportation, even if the underlying offense, even if the underlying arrest, search, what have you, is unlawful. That takes a lot of people some time getting used to. Ms. Livings, what do you think about that? So it's not a defense. Like a defendant in any particular resisting case couldn't say, well, the underlying arrest or the search was against, well, the underlying arrest was unlawful, or the search was against my Fourth Amendment rights, therefore I can resist. What do you think about that?
For me, just really up the ends of the situation, if nothing, if like, excuse me, if an officer is trying to apply to the person and that person doesn't want to, then I can see why we can get positive and stuff.
So I guess what I'm getting at is, do you think someone should be able to resist if the underlying arrest is, or search would be unlawful? No? Does anyone feel that way? Does anyone feel that, you know, some officers overstepping their grounds, they're arresting me for something I shouldn't be arrested for, they're searching me, and I don't feel like they should have the right to search me because I know that this is unlawful, that I should be able to resist that search at that point in time? Anybody feel that way? The way you do. Miss Denzizen?
No, by hand.
Go ahead, sorry, next. Go ahead.
If it's unlawful, why can't I not resist?
Well, let's talk about some reasons for why we have this law. And then that might clear up some of your thing I'll follow. Can anyone think of a reason, Mr. Arante? Can you think of a reason why we might not not prevent somebody from resisting arrest even when the search for arrest is unlawful?
If you believe you did the right thing and it's not a court, it's not unlawful or not illegal.
What about you, Mr. Havard?
Hubert,
Sorry.
you repeat the question.
What are some reasons that we might not make it a defense to the crime of resisting that the underlying arrest was unlawful or search was unlawful?
The facts of the situation couldn't be available present that the person being detained could be on the required information for
Okay.
to make ascertain whether or not the facts are true and that the arrest is lawful.
Okay. Now, Ms. Jacobs, I'm going to ask you a slightly different question. Why might we criminalize resisting an arrest, a search, or transportation?
Because when you're given a lawful order, you are supposed to follow it.
Okay. Would there be any greater concerns for society about criminalizing that particular type of behavior?
I mean, unless law enforcement just runs amok, but in general, they don't.
Yes, ma'am. Mr. Thomas, can you think of a reason we might criminalize resisting arrest?
Maybe simply just to protect the officer.
Protect the officer? Miss Danzizen? There's gonna be one juror every time I do this where I will just constantly mess up your name. I'm gonna try and make it not be your name. Could you think of another person that the law might be trying to protect besides the officer by criminalizing resisting arrest?
Person there interacting with,
Person interacting with the person being arrested?
help prevent things from escalating both ways, either way.
Gotcha. And Miss Bahet?
Yes.
Did you think of another person society might be trying to protect? Or maybe a more nebulous, undefined person?
Sure, Carol, I was like,
Would you agree that those in the near vicinity, who might not even be an officer involved, might not be the person being arrested, but those who are nearby, may get hurt if a person tries to resist the officer and causes a bit of a fight? So that's why we have the law. That's why we criminalize resisting arrest. It protects the officer doing the arresting, it protects the person being arrested, and it protects those around them from any greater danger escalating from that. So back to the original point I was trying to get at with Ms. Bahet. You had an issue with why it's not a defense that they may have committed a crime. Because whether they committed, or am I misrepresenting, am I misquoting?
there should be no resistance.
Okay, if the underlying offense or the underlying arrest or search was unlawful, you think they should have ability to do a bit of resistance?
I think it depends, because a lot of times you find out that it's the officer that makes you, not a good officer. Well, not a lot, but sometimes it comes out that way. So it's an innocent person now has to prove himself, innocent. So I really think it all depends.
No, that's perfectly fine. You can be completely honest about it. It doesn't matter. It doesn't, I don't want to say it doesn't matter how you feel. It does matter how you feel in the sense that you're free to feel that way. It's not a consequence to you whether you want to feel that way or not. But I would like to know if the judge instructed you that's the law, and in a case, if you learned that the underlying arrest was unlawful, could you put those personal feelings away? You could?
Yeah.
Okay.
So I think I'm one that follow the law, just have a conscience of, situations that have happened, and it makes you think, but obviously I'm going to follow the law regardless.
Regardless of how you may feel the person.
Right.
Okay.
Yes.
All right. Anybody else have anything to share about that? Anybody else feel like they might justify their resisting if they learned the underlying arrest was unlawful, the search was unlawful? All right, I'll move on. Now, Miss Jacobs, what kind of evidence would you like to see in a resisting arrest case?
Just see video.
Okay, video, sure. Mr. Thomas, any other type of evidence you'd like to see?
That's what I was gonna say, body cams.
Body camera? Ms. Behet, audio with that video. Besides video, Mr. Turpin, did you think of another form of evidence that might be useful in a resisting arrest case?
What was he running from, or what was the resist for?
Well, how would we know that?
Video, or a statement,
A statement from whom?
victims, witnesses, that's about it, right?
Mr. Underhill, who might be technically the victim and a witness in a resisting arrest case?
When the first witness to the incident, and because if things get out of hand, anything can happen, but we don't want anything to escalate, obviously. But, we have to ensure that, everything is de-escalated in a sound and peaceful manner.
Gotcha. But who is being resisted in a resisting arrest case?
The one who's doing, board members,
Yeah. Who is being resisted in a resisting arrest case?
obviously the officer.
Yes. Thank you, Mr. Dragan. Yes, the officer. So might officer testimony be evidence that we would like to see in a resisting arrest case? Now, y'all mentioned video. Of course, we live in the modern day where we expect a lot of video and we expect body camera footage. What do we know about body cameras? Miss Dan Zeisen, are body cameras glued to police officers? Probably not. Are they attached in a way that just makes them impossible to ever fall off? And Ms. Dyson, would it surprise you that in a lot of cases where officers have to get physical, if a person's resisting and things of that nature, that a body camera might fall off that officer? All right. So when body camera fails, in the sense that it falls off an officer, we're stuck with what the officer has to say. Does everybody understand me?
Word of mouth. Word of mouth.
Word of mouth. Eyewitness testimony. And when that's the case, I want to know, would anyone have a problem convicting based on testimony alone without video camera footage? Ms. Livings, you shook your head no, but you kind of gave me a little grimace before you shook your head no.
I'm from Georgia, so on the cars with cops, there's always a video cam in the car,
Correct.
so nobody can car.
Is it possible that somebody may resist in a place where a car cannot be or away from the vehicle? And if it's such a circumstance, we're left without a video, right? And in such a case, we would only, if we only had officer testimony, would you be able to convict a defendant with officer testimony alone?
All right, I'm gonna have to object to that. That's not the proper procedure. I'm objecting that he's asking for them to decide without hearing any evidence, that if it's just the officer testimony, they can convict them. It is the burden of proof on the state to present all evidence and let them decide the credibility and the weight to be given to their testimony.
Your response?
Your Honor, I'm simply making sure that they treat all evidence equally, and video camera footage is just as equal evidence of guilt or innocence as officer testimony. So I'm making sure if the only thing they heard was officer testimony, they would be able to treat that as sufficient evidence to convict.
Okay, sustain his objection, you can rephrase your question.
If the only evidence in the case was officer testimony, and if you understand that all testimony, all forms of evidence, video evidence, testimony, sworn statements, things of that nature, all must have equal weight to the validity of the evidence if they are admitted. But as the jurors, you will be the deciders of the sufficiency of that evidence, how persuasive that evidence is to you. If the only thing is officer testimony, would that evidence be, I'm trying to think of the word here because I don't want to get objective for him.
The weight. It's the weight.
Correct. Would that evidence be enough to go to the weight of the, would that evidence be sufficient weight to justify conviction in your mind?
You asking her or you asking everybody?
I'll ask her, but you seem very glad, so I'm gonna get to you next, don't worry about it.
Being here,
Okay.
I would also like to hear from the victims and if that's okay.
So the victim would be the officer.
No, I mean. Yes, but, yeah, the defendant, but I would like to hear on both cases, because I don't want to hear one as being one-sided, and I don't know what happened on their point of view.
Understood. Are you aware that in criminal cases, the defendant enjoys the right to silence? So the defendant doesn't have to speak, nobody can make him speak. So if you need to hear both sides, would that be something that you, would you be able to be fair and impartial if you only heard one side?
I'll be okay with one side, it's optional if they want to speak. So I'll be okay with just one side, if he has a choice to speak, if he doesn't want to.
Okay, so you would then be fine with officer testimony alone? And you could convict? If the evidence was sufficient in your mind, you would. Mr. Blaze,
Yes, sir.
you wanted to speak on that matter?
Yeah, that would be a little difficult, to talk about. Because if my job is to evaluate everything that you present, he doesn't have to speak. Well, you have to have it put together, because if you're telling me that I gotta go off one statement, I can't hold the fact that he doesn't have to speak against him. And then you tell me there's no video in the area and the officers camera fell off. I mean, that's a tall task.
Okay, so in your mind, would you be unable to convict if one witness, one officer by themselves on their testimony alone was able to prove each element of the offense?
No, I would still be able to do it, but it goes back to what I was saying about the weight, when I highlight the weight of that testimony, we have to give weight to it to decide whether or not it's true, credible, whatever the case may be. It's just not gonna be, oh, he said it and that's the gospel. It has to line up with you have to give it weight.
Okay. So would you be saying that not to put words in your mouth, feel free to correct me, but would the defendant be starting ahead of the state in your scenario where because he enjoys the right to silence and we have the burden to prove each and every element of the case, you're gonna scrutinize that evidence more severely because you don't have to hear from the defendant? Is that what you're saying?
Not at all. Both of you guys start at 100 based on the law.
Okay.
He just has a better seat because he doesn't have to defend, or he's innocent until proven guilty. So with that in mind, it's real simple for me. You either prove your case or you don't. It has nothing to do with him getting an advantage or you getting an advantage. Either you can prove it or you can't. If you can prove it, you win. If you don't, you don't. But neither one of you guys are at an advantage. He just doesn't have to speak, and he's presumed innocent until he's proven guilty.
Correct. But we have a taller order if it's only officer testimony.
Absolutely.
Understood. Now, I was gonna get to this later, but since you harped on it, or mentioned it, is a person, let me just ask that we complete this phrase. A person is innocent.
Unless.
How you change your answer?
Unless,
You said until proven guilty. I heard some of y'all say nobody's gonna raise their hand. All right. We stand eyes and then you're being honest. It's commonly misconstrued as innocent until proven guilty, and I blame TV for that. It's actually innocent unless proven guilty, because the word until implies that something will eventually happen. We do not know if the defendant will eventually be proven guilty. It is therefore unless they happen to be proven guilty. Now I want to get some of y'all's opinions on officers, since we will be relying, I guess, as you can assume, pretty heavily on their testimony in a resisting case. So I'm gonna give y'all a scale from 1 to 4. One being that you have a very negative. Y'all can't see that?
You gotta get some.
Yeah, it's really not.
Hang out.
It's little like this thing.
Hang out.
What's the matter?
All right,
Give him a darker one.
everybody see it now? I might need to turn it a little bit. Can y'all still see it over there? Yeah. Trying to get everybody. All right. So one being that you have a very negative opinion of these officers and you find them to be very untrustworthy. 2 being that you have a slightly negative opinion of police officers and you find them somewhat untrustworthy. 3, again, you have a slightly positive opinion of police officers and you find them somewhat trustworthy. And 4 being that you have a very positive opinion of police officers and you find them very trustworthy. I'm gonna go down the line and I'm gonna ask how everyone feels. If you need that, you need your number repeated, I'll be more than happy to do so. So Mr. Bergen, what would your number be?
I generally do police officers in
Okay. Mr. Underhill? Or Mr. Turpin? Or Ms. Lydians?
I don't know, you beat the one before again.
All right. 1 is very negative. You have a very negative opinion of police officers. You find them very untrustworthy. 2 is slightly negative, somewhat untrustworthy. 3 is slightly positive, somewhat trustworthy. And 4 is very positive, very trustworthy. Miss Bahet?
4.
Dan Zeisen?
3.
Thomas? 3. Ms. Jacobs,
4.
Ms. Vega,
3.
Ms. Lau Beenan,
3.
Ms. McBride.
Mhm.
Mr. Lower Mayor,
3.
Mr. Hubert,
2.
Mr. Arnett.
3.
Mr. Blades. 3. Ms. Conley,
4.
Ms. Wright,
3 to 4. It's a little tricky to generalize.
Mr. Kokonos,
Start with the 3 and have to earn the 4.
Mr. Trady.
3.5.
3.5, all right. So we covered the presumption of innocence, we covered the right to silence. Now, excuse me here, I want to ask y'all, or talk to y'all about a bit about the burdens of proof in this case. So as y'all may know, the state has, in any criminal case, has to prove the guilt of a person beyond a reasonable doubt. Now, there is no definition for what beyond a reasonable doubt is, but I think we can come to a bit of an understanding of what it should be based on the other two burdens of proof, which do have definitions. And this is, I think, very simply broken apart in a bit of a grading scale, because we all went to school for about 12 years through high school at the very least. And we all got grades, so we're kind of familiar with that. So we start with P, C, and D. P is preponderance of the evidence. It's what you see in a civil case when you're bickering over civil issues requiring money, things of that nature. It's simply more likely than not. Does the evidence pass that the plaintiff has to present to the plaintiff in a civil case is the closest thing to a prosecutor. They have the burden of proving their case, while the defense doesn't have to do anything. Of course, they don't enjoy the right to silence in a civil case though. But it's basically, does the evidence pass or fail? Does what the plaintiff is what the plaintiff trying to prove more likely than not? So we see that as a pass, fail. Great. It either passes or it doesn't. Then we have clear and convincing. Clear and convincing is enough evidence to create a firm belief or conviction in your mind about the truth of something. So that something did or did not happen, you have to have a firm belief in your mind that something happened. And I would argue that that is equivalent to getting a C in school. You got your F in your pass fail, you either failed the class. B, you passed the class, but not by much. Or C, which we consider average in the United States, is you clearly passed the class. You clearly showed enough to at least score average in the class's grade. Which leaves beyond a reasonable doubt. And as you notice, B and B, there's a B and beyond. And that's because I would say being above great evidence is what you should consider to be beyond a reasonable doubt, in my opinion. Now, we as the state are always going to do our best to try and bring you grade A evidence. But sometimes with the passage of time, people moving, people changing numbers, you can't get a hold of everybody that was involved, or it's a resisting arrest case and the officer's body camera just happened to fall off. And all we're left now is testimony. And while that video showing everything may have been grade A evidence, all that we're able to bring you is B grade evidence. We're able to bring you the testimony, which is enough to prove it, but it might not be the best thing that we could possibly do in the world to prove something happened. The best thing would obviously be seeing the video that happened and you can see it for yourself. Does everybody understand what I'm getting at here? Does anybody, would anybody have a problem using B grade evidence to make their decision in a case? All right. Is there anything that I haven't discussed with anyone that you may think I need to know about, that you think I should know? Mr. Blaze?
I think the defendant is my classmate.
Something I did forget to ask. Does anybody know anybody up here? Mr. Blaze, do you know, Mr. Slaughter?
I think it's my classmate. I'm not sure, but I'm almost positive.
From what year? What have you know?
Jose in class 06, went to Oldham,
That's all.
2003, 2002, 2002.
Okay. Would that affect your decision in this case? Would you be able to be fair and impartial considering that you know the defendant?
Yep.
All right, well, since you brought that up, does anybody know me, my co-counsel, Mr. Burbank, or Judge Holmes? You're bringing that up, just
Mr.
like,
Burbank, yeah, I know Mr. Burbank from, just watching him on, the YouTube.
now because you're a fan of Mr. Burbank.
No, not Burbank.
Who was- Sorry, I was about to say something in that video. All right, well, I won't hold you. My fault for not remembering. Oh, now I just remembered. Haha, I'm still here. Mr. Bergman, were you on a criminal case before?
Yes, sir.
And did you reach a verdict in that case?
Yes, sir.
Do you remember if it was guilty or not guilty?
It was just a couple months ago, it was built.
Miss Jacobs, you were on a criminal case, correct? Did you reach a verdict in that case?
Yeah.
Was it guilty or not guilty?
Guilty.
Ms. Lyle Beanon, you were also on a criminal case?
Yeah.
Did you reach a verdict in that case? And it was guilty or not guilty?
Not guilty.
Mr. Arnett, you were in a criminal case? You were never a juror on a criminal case? Okay, fair enough. Ms. Conlon? Were you a juror on a criminal case? Oh, Ms. Conlon?
Yeah.
Sorry, looking at the wrong person.
Yeah.
You were a juror in a criminal case?
Yeah.
And you reached a verdict?
Yeah.
And was it guilty or not guilty?
Guilty.
Now that will be all. Thank you so much for your time.
Okay, Mr. Burbank, the panel is yours.
May I please court?
Yes,
Again, good afternoon, ladies and gentlemen. The state asked you a lot of questions and I'm not gonna be as long as the state, so that's gonna be real short, okay? Will everybody agree that we have not come up to an agreement ourselves? That is, Mr. Slaughter and the state between us. Everybody agree with that? Everyone agree now that we have to now go to the citizens in order to decide. And that's you, ladies and gentlemen. And when I do trials, and every trial is extremely important, because if you are sitting in the same seat as Mr. Slaughter, your freedom is at stake, because one of the possible punishments is jail time. Okay, and for a class A misdemeanor, it's up to a year, which y'all, if you find guilty, and I'm not saying that you will, but you're also going to then be asked to determine the punishment. Okay, and my point being is, it is extremely important, whether you're here or you're up in district court. Agreed? Can everyone be fair and impartial? Raise your hand if you can. Okay. You scratch. Is that maybe?
No.
No, okay. I have a little bit of rendition besides the reference proof beyond a reasonable doubt. I'm old enough, and I think the judge is old enough to know that at one time the court did have a definition of what beyond a reasonable doubt is. Right? And now what they tell you, or what they tell the jury is that you have to use your reason and common sense. Okay, how many people have reason and common sense? Raise your hand, everybody's sure. How many people are married and have reason and common sense? No, but it is reason and common sense, right? I would submit to you that everyone during the day makes decisions, correct, in their life. Everyone makes important decisions, don't they, at some time? For instance, if you have kids, do you let them go out Friday night and when you come back at 11 or 12? What are they going to do? Do I buy a house? Do I not buy a house? Do I do this or don't I do this? And so it's important decisions, correct? And that I would submit to you is kind of towards what beyond a reasonable doubt is. It is a situation in which you have to make a decision that you rely upon, okay, in the most important of your own affairs. Not just me, it's not the, but that's just me, is that, I think that's what proof beyond a reasonable doubt is, right? And the state didn't allude to this, but if we were down the hall to the family, division, it is clear and convincing evidence if they want to take the children away. Right? So if they file a suit petition to terminate your rights, all they have to do is that C, whatever it is, grade that the state was talking about, and that is to take your kids away. Well, this burden is even higher. And I would submit to you what I ask you all to do for the 6 that are picked is a decision that you'd make that you rely upon in the most important of your own affairs, because someone freedom is at stake. All agree? Now, Ms. Blake, you had made mention in reference to, I guess, what you want to see, what you don't want to see, in reference to evidence, correct?
Yes, sir.
We had an issue with that. And along with that, there were a lot of things in reference to the, I guess, the grades between 1 and 4 in reference to the police officers. What I'm asking is that can everybody, whatever the witnesses are, can you be able to place them all on a level playing field? Can everyone do that, whether it's a police officer, a layman, whatever it is? Everybody starts at 0. Fair enough?
Yes, sir.
And then based on whatever their evidence is, the testimony, which is evidence, you have to judge then the credibility and the truthfulness and the reliability of what they say. Does it make reason and common sense with what they're saying? Okay, fair enough? And that's all I ask. Is that when you sit there, the 6 of you sit there that are picked, you listen to what the testimony is, you look at the evidence that's presented, if there's video, if there's pictures, whatever it is. And then once you have that, the judge is then going to give you the law. You've been in a jury before, and you have too, in which it's a jury charge. And it's, and they say, it's sworn an oath to uphold the law. And so you apply what you've heard and what has been admitted into evidence. And then apply it to the law that this judge gives you. Fair enough? And then you walk back into that door and you make a decision. And that's all I ask you to do. As a defense, we can't make up our decision. Fair enough? Can everyone do that? Is there anyone that can? Now, I know that you all have in reference to the 1 and 4, there were some 2s, there were some 3s, there were some 4s in reference to police officers. I would represent to you and I would submit to you, and would you agree, that everyone looks at things different. Somebody says it's partly cloudy outside. No, it's partly sunny. I think it's about almost dusk. No, it's dark. I can't see. Or the car was green. Well, maybe it was blue. Or maybe there were 3 people instead of 2 people at the scene. Would everyone agree that everyone has their own perspective of what was taking place? Agreed? And I think that's what you then, as a juror, have to look for. Okay? What I'm looking for is 6 people to listen, to take in, to get the law and make a decision. Let's put it on the table. Let's decide. Guilty, not guilty. And can everyone do that? Is there anyone that can't give 110% attention during the next day or so of this trial? Take it by a silence that everyone can. The state does have the burden of proof. And in fact, the court is going to admonish you, if the decision is made that the defendant does not testify, I can sit on my hands and I can make Mr. Slaughter sit out on his hands and do nothing at all. I don't even have to cross-examine witnesses. I can just simply. And the judge is going to instruct you that you cannot take that into consideration in your deliberation. Does anyone have a problem with that? Because I just told you, let's put it all on the table and decide. But the law says, well, there may be only a couple of things on the table. Does anyone have a problem with that? Take it by silence that everyone can follow the law, and I'm gonna hold you to it. The next thing is that during this trial, and I have not been in a trial since I've started, you see my gray hair, that I have not objected. And you're probably gonna wonder, why am I doing that? Well, there's a couple of reasons. As attorneys, you know that the law is made up of attorneys, and we like to, well, we think about this and we think about that, and there's a library full of books and opinions. Right, so we like to hear ourselves talk and object and do whatever. What I'm trying to get at is if I think that the state has crossed that boundary, the only way I get to preserve an error is to object. And this gentleman right there with the cone over his mouth is taking in all my objections for the record. If the judge does something that I think is outside the boundaries, respectfully, I have to object to perfect the record, to preserve the record. Okay, so hold that against me if I do that. Okay, it isn't not trying to do something to him or whatever. I have to protect my client. Okay, no. I will. The second thing is that they tell me there's only one way in and out of this courthouse, but I know that's not true. But there is really only one way in and out of this courthouse. And the reason why I say that is once the 6 are selected and there's really one elevator, there may be a time during the trial or out there, you may come up or I walk by and you say, hey, hi, thank you, or how's the day, or isn't it a great day? And I turn my head and I don't say anything. And you're probably gonna say, oh, typical person. I cannot speak to you. I cannot have it's a side of the Friday. I can't associate with you if you're a member of the jury. Fair enough. What I will tell you is, and what I'm asking in reference to, you all make this decision, regardless of your verdict. Okay, because I'm asking you to decide. Okay, my client is asking you to decide. Is that whether it's guilty or not guilty? If you have any questions afterwards, I'd be more than happy to answer. Fair enough? I believe in the system. I've been on both sides. I believe more on the defense side, time-wise, but I've been on both sides. And I believe in the system. This is the only system in this world that allows citizens to judge another citizen and allow citizens to also to decide punishment if found guilty. And I believe in this, good, bad, or indifferent. Fair? Now, with that being said, and I told you I'm not gonna take very long. Is there anybody that says I can't be a juror? Can't be fair and impartial? Can't use your reason and common sense? You've got something that's gonna be on your mind, or something you can't take the next day out of, which I believe maybe tomorrow we start. It shouldn't be a very long trial, but it's extremely important, Mr. Slaughter. And also the state. It's your last chance. Good enough. I look forward to trying this case to six their pick.
Okay, ladies and gentlemen, at this time, we're gonna ask that you will go out into the hallway. We may call some of you back in for some follow-up questions. And so you can use either one of the two doors to exit the courtroom. So at this time, everyone please stand as the panel exits the courtroom. Yeah. Y'all can sit down. Okay. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 25 CCCR 0951. The case is styled the state of Texas versus Travani Slaughter. Let the record reflect that Mr. Slaughter is present in court with his attorney, Attorney Tom Burbank. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon and Attorney Samuel Masradian. State, are you ready?
Yes, sir.
Defense, are you ready?
Go right ahead.
Okay. Ladies and gentlemen, when your name is called, or if your name is called, please go to the jury box. There are some badges on the top of the jury box. And take one of the badges and pin it to your clothing. Miss Glenda Segura, who is one of our court coordinators, she will be calling the name. Again, when your name is called, please walk up to the jury box, grab a tag, have a seat, and place the tag on. Okay, at this time, Mr. Segura, you may go forward.
Robert Underhill. Brianne Van Siven. Justin Thomas. Angel Vega. Jarvis Lau Beeman. Keisha McBride. Jared Lorimer.
Yes. Okay, members of the jury, at this time, I must administer to you the second of the two oaths that I previously mentioned. So at this time, I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, "I do." Do each of you do solemnly swear in the case of the state of Texas versus Giovanni Slaughter, you will a true verdict render according to the law and the evidence, so help you God?
I do.
Okay, you may put your hands down. Okay, members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of laws, composed of facts as it applies to the particular case. The facts comes from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and other court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You're the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can hear the discussion on the point of law. And the reason for this, as I told you earlier, you are sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather his equipment and take it with him. And the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you should disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of evidence and make reasonable deductions from the evidence. Since the state has the burden of proof, it also has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss this case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or on social media or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. Make sure that you wear those badges at all times because those badges identify you as a juror in this case. Now, ladies and gentlemen of the panel, those who were not selected to serve as jurors in this case, I know some of you may be disappointed because you spent your afternoon here thinking that you was going to be selected as a juror in this case. However, as you're aware, we only have a limited number of jurors who will be selected. You might think that you wasted your time by coming here today, but you did not waste your time. And the reason why I say you did not waste your time is because, as I mentioned to you earlier, we had 3 dockets today. We had a trial docket, pretrial conference docket, and an announcement docket. We had somewhere in the neighborhood of 60 cases. A lot of those cases was disposed of today. And the reason why they was disposed of was because of people like you who showed up to serve on a jury. You know, a lot of times, and I think Mr. One of the attorneys mentioned it, that in the past, they may have received an offer from the state to settle the case. We call that a plea bargain. And sometimes people say, you know what, they can either accept or reject the agreement and have a right to go to trial. Some people decide that they would like to go to trial because sometimes they believe 1 or 2 things is going to happen. Some people think that 1, jury's not going to show up, or 2, witnesses not going to show up. But on days like today, when jurors show up, then it's not uncommon for some of those individuals to have a change of heart and say, you know what, that offer that the state made a few months ago, it looks pretty good right now. And so it was because of your presence, the fact that you were coming down here this morning, this afternoon, that we were able to move cases. And on behalf of the citizens of Jefferson County, on behalf of the staff here in County Court Law Number 2, I'd like to thank you for taking time out from your busy schedules. Now, I know that when you came to court this afternoon, you probably looked over the door and you said, oh, this is County Court Law Number 2, Judge Terrence Holmes. Tell Judge Terrence L. Holmes presiding, oh, this is Judge Holmes' court. I'm in the right place. Well, this is not my court. This is the court of Jefferson County. In fact, this is for the citizens of Jefferson County. You are the citizens of Jefferson County, so this is your court. So anytime that you're in the area of County Court at Law Number 2 of Jefferson County, Texas, you can come and have a seat in your courtroom. In fact, you can sit in the area that you're sitting in. We call that the peanut gallery. But it doesn't mean that you can bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on, and I'm sure you'll find it very interesting. So at this time, your jury service has concluded. It's 4:30. Our district clerk's office closes at 4:30. If you need any excuses from work, just let us know. If the district clerk's office is not open, we'll be happy to give you the letters that you need. And at this time, I usually give everyone a handshake. However, you know, we still have COVID and other things in our community. However, I will give each and every one of you what I call an air handshake. So at this time, thank you for coming down here and serving on the panel in County Court at Law Number 2. The bailiff, she has letters for you. Each and every one of you can get a letter. Once you get a letter, you're free to go. And each and every one of you have a blessed day. Your excuse.
No. You have, if you need an excuse, you can go.
Yeah, he can come right here and have a seat in this chair if the district clerk's office is closed.
What? Your Honor?
Yeah, right here. You can sit in that first chair. Yeah, we'll have our clerk to come back.
I don't know, thank you for putting up with me.
Oh, you're wonderful.
Thumbs up.
Thank you, Mayor.
You're.
Okay, now, ladies and gentlemen of the jury, if I'm not mistaken, state, you're gonna call your first witness on tomorrow, is that correct?
Yes, Your Honor.
Okay, so we're gonna reconvene at 1:30 on tomorrow. Make sure that you have a seat outside the courtroom, and when we are ready, the bailiff will come and get you to bring you into the courtroom so that we can start the rest of this trial. Now, just for a preview of what to expect on tomorrow. Tomorrow we'll have, I'll read the information. The information is a charging instrument. In misdemeanor court, we call it an information. In district court, they call it an indictment. Okay, it's just a charging instrument. We'll read the charging instrument and the defendant will enter his plea to the charging instrument. If he enters pleas of not guilty, then we'll proceed with an opening statement by the state, and if the defense would like to have a follow-up with opening statement, they can, or they can reserve their opening statement. And then after opening statements, we will proceed with the state calling their first witness, and we'll proceed from there on. Okay, so again, on tomorrow, make sure that you're here promptly before 1:30. When we're ready, we'll call you in so that we can start this trial. So at this time, you are excused. Everyone, please stand as the jury exits the courtroom. Make sure that you wear your badges. You can take your badges home with you. Okay, you need an excuse too?
Yes.
Okay, y'all just have a seat. We'll get our clerk in here. Mr. Burbank, you excused. Ms. Slaughter, you excused as well. Prosecutors, you also excused.
Thank you, Your Honor.
Okay, this will conclude today's trial. Call number 23 CCCR 0951, case of style state of Texas versus Trevani Slaughter. Court will reconvene at 1:30 on tomorrow, June 2nd. In County Court at Law number 2, Judge Terrence Holmes presiding. Everyone, please have a blessed day.